Well, good afternoon, everybody. My name is David Locke. I'm a Silk at Landmark Chambers, and I'd like to welcome everybody to this webinar on the Human Rights Bill, or the Bill of Rights, as it technically is. This is the first of three webinars we're doing on the bill. Can I start with a few housekeeping points? First of all, your microphones are automatically muted, so you won't need to adjust your settings. Secondly, we very much welcome questions throughout the session. If you want to ask questions, please put them in the Q&A section, which will be found at the bottom of your screen. And if you'd like to remain anonymous when asking a question, make sure you tick the send anonymously box before submitting the question. We'll endeavour to answer as many questions as possible today, but as I say, this is the first of three seminars. There's another seminar on next Wednesday and then another one next Friday. So if we don't get answers to questions, or the questions which are in areas that are going to be covered next Wednesday or Friday, we may defer off to answer the questions then. If your connection is lost at any point during the webinar, we invite you to rejoin the webinar simply by re-clicking the original link. And finally, as this is a webinar, I can confidently tell you I can't give you any instructions about fire alarms. I can't give you directions to the toilets. And my apologies that even though this is a Friday, we won't be able to offer you the usual drinks and canapes afterwards because this is all online. Sorry about that. My job is to chair the session today, and then there will be three detailed talks by Fiona Scolding, Queen's Counsel, Tim Buley, Queen's Counsel, and Charles Bishop, who I'll introduce in a moment. But the programme is this. First of all, I'm going to give a short introduction to the bill, and then Tim is going to give a talk on the interpretation of convention rights and the different way in which it will change once if on the assumption the bill is passed. Then Fiona is going to tackle the difficult subject of the changes to the way the Declaration of Incompatibility are going to work under the new bill as compared to how they are at the moment. And finally, Charles is going to cover an area which may turn out to be really quite important in practice, which is that a new permission stage will be introduced in order to bring any claim or advance any point which involves human rights issues. It's great that we have these three excellent practitioners. Tim will be known to many of you. He specialises in all areas of public and regulatory law, human rights, planning and environmental law. He appears an advocate in over 200 cases in the High Court, the Court of Appeal, the Supreme Court, for all kinds of individual clients challenging state action, and for public bodies and commercial bodies. He is noted in the directories as being somebody who is so good that your heart sinks when he's on the other side. So the answer, of course, is to get in advance and have Tim on your side rather than against you. Fiona Scolding is another very well-known Silk and highly respected Silk at Landmark Chambers. She practices in human rights law and all aspects of public law. She sits as a part-time upper tribunal judge, and she's appeared at all levels of court on issues relating to human rights. And she was counsel to the inquiry in various of the strands of the sex abuse inquiry, and that involved a detailed consideration of human rights of everyone who was involved in the inquiry process. And she's currently appearing for a large group of victims in the infected blood inquiry. She's joint head of Landmark's public law group, which is now 54 strong and maintains a wide practice across all areas of health and social care, acting for both individuals and public bodies. Charles is a junior barrister at Landmark. He joined us in October 2021, and we're delighted to have him as part of the team. He specialises in public law, including human rights law, planning and environmental law. And prior to starting pupillage at Landmark, he was the legal and parliamentary officer at the Immigration Law Practitioners Association, where he led on their parliamentary work related to Brexit, and therefore is very familiar with the interesting dynamic between law, policy, and politics, which no doubt will assist him when he's talking. So it falls to me to introduce the bill, and I'll start by saying this. This at the moment is only a bill. It's a bill that the government has introduced and invited Parliament to pass. Human rights have been a hot topic issue for the present government. If anybody wants to see a satirical view on the background, I strongly recommend viewing the Patrick Stewart sketch, which the link is on the screen, which follows the forum of a well-known Monty Python sketch of what have Romans ever done for us, and what's the European Convention of Human Rights ever done for us. It's one view of the usefulness of human rights and the Human Rights Act. Another view is Human Rights Watch, who have described this bill as being a power grab by the executive, and that far from being a Bill of Rights, it's a Bill of Wrongs. That's their view. The government sees it as rebalancing human rights between individuals and the executive, between decisions taken in the UK and decisions taken in Europe. And there are many views. It's interesting to see what perhaps a leading academic public law commentator, Professor Mark Elliott of Cambridge University, has said. He said, we can now see then that the Bill of Rights forms part of a much bigger picture. The Deputy Prime Minister, Dominic Raab, claims the Bill of Rights is a rights-enhancing instrument, but it's nothing of the sort. It will in fact weaken human rights protection, and as a result it will weaken the ability of individuals and the courts to hold the government to account by reference to human rights standards. The real aim of the Bill of Rights is not to enhance human rights protection in the UK, it is to shield from scrutiny on human rights grounds a government whose authoritarian instincts are increasingly evident. That is a legitimate view. It's one that some commentators share. Other commentators think that this is an appropriate rebalancing from a human rights system which has got out of control. It's not our job today to express a view as to who's right about this. We're not taking a position as to whether or not this is a wise thing, a politically appropriate thing to be done. That's not our job. Our job is to try and explain what the bill will do in practice if it's passed, and therefore allow a greater informed debate, and also to allow you to prepare for your clients, whether you act for the government or whether you act for other public bodies or for individuals. So the new framework within which human rights will have to be litigated is properly understood. So what are the main proposed effects of the bill? Well, the first thing to stress is this is just a bill, and it's a bill before Parliament. And the one thing we can be pretty confident about is that the final bill, if it ever emerges as an act of Parliament, will not be in precisely the form it is at the moment. Virtually all bills are amended to a greater or lesser extent as they proceed through Parliament. This is a bill where there will be intense scrutiny, particularly from the House of Lords, and the extent to which that scrutiny will result in changes to the bill is something that we will only know in due course. So what we're describing at the moment is the start of a process. We need to be cautious about whether predicting what will be at the end of the process. But the effect of the bill is to repeal the Human Rights Act 1998 in its entirety. Interestingly, the UK has not withdrawn from its position as a signatory to the convention. We remain a party to the convention. And there's a certificate under Section 19 of the Human Rights Act 1998, which of course remains in force at the moment, that this bill is consistent with our convention rights. There are some who say that's not correct, but in practice, that'll have to be decided in due course in the courts and probably in Strasbourg, not in the UK. But the fundamental building block that it's unlawful for a public body to act in contravention of convention rights, presently in Section 6 of the Human Rights Act 1998, remains as part of this new bill. So Clause 12 repeats the Section 6 provisions regarding the statutory duty on public bodies not to act in breach of convention rights. But what the bill says it's doing is a fundamental rebalance between the rights of individuals who are seeking to complain about government and government bodies, public bodies, acting in breach of their rights, and those public bodies, and redressing, as the government would see it, the balance between decisions taken domestically in the UK and the effective decisions taken in Strasbourg. As part of that, the government is introducing a permission requirement to raise HR issues under Clause 15, and Charles is going to look at that in detail later this morning. There is a substantial shift in rights as between journalists and personal confidentiality. This has been the subject of intense litigation, and the government has taken the position essentially to support the press's right to report against individuals' right to confidentiality in information about them. That's Article 10, Article 8 balancing issue, which has been debated extensively, and in broad terms, and I'm going to say more about that, the government have come down very firmly on the side of the media's right to publish, as opposed to individuals' right to stop the media publishing what they would say is confidential information about them. There's an interesting provision in the bill that interim orders of the European Court of Human Rights will no longer have effect in the UK. And this is said to be compatible with the scheme of the convention, even though Rule 39 of Rules of Court of the European Court of Human Rights gives the power of the court to make interim applications, albeit only in exceptional cases. It's arguable that the binding nature of decisions of the European Court under Article 46 of the Convention only applies to a final judgment. And if that's the case, one queries whether the compliance with interim judgments is part of the final judgment or is an optional extra. There are other provisions. There are provisions that limit damages for breach of human rights under Clause 18, which may prove to be quite significant. There's a narrowing of sufficient interest for judicial review under Clause 16. So essentially only those who are victims can now proceed to challenge breach of human rights by public bodies. There are substantial limitations on the powers to avoid deportation of foreign criminals by relying on Article 8 rights under Clause 20. There is an interesting observation in Clause 9, which seeks to assert that you can't use human rights to undermine the right to trial by jury. And frankly, it was unclear if the right to trial by jury was ever under threat, possibly, at least in theory, for a complaint about the lack of duty to give reasons. This is a quick overview of the bill, and I can only do that. Clause 3 removes the interpretive provisions in Section 3 of the Human Rights Act as it exists at the moment. I'm sure Tim will be saying more about that. That's likely to be a substantial change. The bill makes the UK Supreme Court, and not European Court of Human Rights, the ultimate arbitrator of convention rights as they apply in the UK. And I'm not clear how that could be compatible with Article 32 of the convention, but as a Section 19 certificate, that's something that we'll have to work out in practice. there are substantial changes to the process of making and the consequences of making a declaration of incompatibility. Fiona Scolding will talk more about that. And there are changes which weaken the law on the extent to which positive obligations in the convention can bind on public bodies, which are all in clause 5. So that's a brief introduction to the scheme of the bill. It completely repeals the Human Rights Act. It introduces a new and reasonably different approach to the way that the citizens and public bodies interact and how human rights work, and will be applied by the courts if the bill is passed. I'm now going to pass over to Tim Buley to talk about the changes proposed for the interpretation of conventional rights, an area which might seem fairly academic, but in fact, I think is likely to have a substantial change in practice. Over to you, Tim.
Thanks, David. So yes, so as David said, my topic is the interpretation of convention rights, although in fact, I think it needs to be really interpretation of convention rights and other interpretation issues, because they're not being covered in other parts of the sessions we're doing. And I'm going to talk about three things. First of all, some observations on the interpretation of the bill itself. How does one go about interpreting the bill? Because it's pretty unclear in some situations. Secondly, very briefly, because it's not within this topic, but I just think it's an important topic, is something about interpreting other legislation and the repeal of Section 3 of the Human Rights Act. And then thirdly, interpretation of convention rights per se. That is definitely an important topic, because it will affect how the courts, well, potentially might mean a greater willingness on the part of domestic courts to depart from Strasbourg case law in particular on what the effect of the ECHR is, and maybe, and this is certainly what I think the government would say it hopes for, a much more traditional, small c conservative interpretation of the convention, a bit more like a sort of originalist interpretation of the convention, which of course we've seen a little bit of those sorts of arguments recently with the US Supreme Court decision making recently on matters such as Roe and Wade. David is absolutely right. It's not our job to make political statements, but I think I need to address the elephant in the room, which is that I do think this bill is pretty strangely, even incoherently drafted, and one can't get away from that. So just looking at it as a technical lawyer, I'm afraid I can't get away from being somewhat critical of the current drafting. What the implications of that are, because we may end up with this text in the ultimate result, I don't know. But one can't just ignore that. So for those of you who are partisans of the bill, forgive me for that, but hopefully you'll take it as constructive. Just by way of preliminary then, the bill is available here. I think what I meant to give you is that's a link, but you won't necessarily be able to use it. But there's a link there to the bill, which you can get online in any event. And when enacted, note that it will unusually not because it's just an act of parliament, no more and no less. It's not some sort of entrenched Bill of Rights that overrides an act of parliament. Nevertheless, it's not going to be called, it's now the Bill of Rights Bill. It's not going to become the Bill of Rights Act, the BRA. It won't be being put into skeletons. It'll just be called the Bill of Rights 2022, assuming it gets through in 2022. Okay, so to the first of my topics. As I say, it's drafted in a very odd way, at least by comparison with domestic legislation, including the Human Rights Act itself, but any other domestic legislation that I've ever seen, and including other constitutional statutes which we've seen in recent years, like the European Withdrawal Act. They're all drafted in a fairly familiar way, with quite a high level of legal precision, and so that the operative clauses, what become the sections of the legislation, all have a very clear effect, not just a purpose, not just a declaration, but they do something, they change the law in some way, or they have a legal effect. That is not the case with many, many provisions of this bill. And that, it seems to me, that's quite an important point to have in mind when you're thinking about how the bill will be interpreted, the Bill of Rights, if we call it that, will be interpreted in due course by the courts. So for example, I'll just give an example of this very first clause of the bill. I won't read out the whole thing, but I'll pick out a few bits. So this act, it says, reforms the law relating to human rights by repealing and replacing the Human Rights Act 1998. That's just a declaration of intent. It's not actually repealing the Human Rights Act. That's done in a schedule. I think you can see further down, it's Schedule 5. It goes on to say, again, it's a declaration of intent. It doesn't have any real legal meaning. In particular, this act clarifies and rebalances the relationship between courts in the United Kingdom, the European Court of Human Rights and Parliament by ensuring various things. Looks like a preamble. Ironically, it seems to me, it's the sort of thing you'd expect to see in European legislation, where the preamble is quite an important part of the overall legal text and says something about the purpose. It's not something you expect normally to see in domestic legislation, or that we're familiar with here. And so it says, declares loud and clear, for example, 2A, it's the Supreme Court and not the European Court of Human Rights that determines the meaning and effect of convention rights for the purpose of domestic law. Well, so be it. But of course, that is already the case, and is almost inevitably the case under our constitutional arrangements. It's certainly without some fundamental rewriting of our constitution. The Supreme Court is supreme on domestic law. It always has been. European Union membership was different, but the European Council and ECHR membership, that was never altered. And that point, you can see further down, it is affirmed again in a slightly different language, repeated again, and this is all, I think, quite important to interpretation. So clause 1.3 at the bottom of the slide here, it is affirmed that judgments, decisions and interim measures of the European Court of Human Rights are not part of domestic law and do not affect the right of Parliament to legislate. Well, again, so be it, but of course that's already true. It's always been true. It's never not been true under the Human Rights Act. So again, you've got a whole, what looks like a whole clause of the Act, and there are others, which isn't doing anything. An even more clear example, which I won't go to, is clause 9 on jury trial, which effectively does nothing at all. Now, all of that is very odd. It seems to me it throws up some difficult issues about the interpretation of the bill, and in particular, those are relevant in turn to how the courts might interpret convention rights going forward. Because the courts are going to be faced with a difficulty in how to interpret these provisions. Does it give them some effect, despite the fact that it looks like they don't? Does it kind of take account of them as mood music when interpreting other sections of the Act? I don't know the answer to that. It's a problem, a legal problem that courts haven't been previously faced with. Some of these provisions appear to be aimed not so much at lawyers or even at courts, but at the court of public opinion. They're making broad statements of kind of intent, political statements almost, and that's why one can't quite avoid politics when looking at this bill. It's important, it seems to me, though, and you can see this on the previous page, because all of this is, in a sense, a reaction to the Human Rights Act. You cannot understand the bill without first understanding then that it's a reaction to the Human Rights Act, or to a particular perception and/or misunderstanding of the Human Rights Act. So if we just go back, it may well be the view of some in government, some of those who are promoting this bill, that under the Human Rights Act, judgments of the European Court of Human Rights are part of our domestic law. That may well be the answer, and it may well be the explanation for the bill, but of course it's just not right. Now, where does that leave us? Well, it seems to me that it's possible, one way of approaching these provisions then would be to say that the courts should take account of them as a sort of parliamentary declaration of intent, that UK courts should not only be permitted, as they already are, but encouraged to depart from Strasbourg case law in interpreting the ECHR. And so, and I'm sorry that the slide I repeated out, but what I've said in the slide, but so the courts might interpret that as quite a strong injunction as to how they should go about interpreting the European Convention, even though, as we'll see in a moment, you don't find that explicitly in the text of the Act. I don't know about that. I'll come back to it at the end of the talk. On the other hand, there are other difficult questions of interpretation which go beyond that, because, as David alluded to, many people have said, and it seems to me to be clearly right, that one of the things the Act does is undoubtedly take away rights. It certainly, other than a very few cases, doesn't grant you rights. Does that mean it should be interpreted in accordance with the principle of legality, for example, and other similar sorts of principles of interpretation, so that you interpret the bill itself restrictively so as to preserve human rights, the European Convention, as much as possible? The case on the case best known on that is ex parte Sims. Again, we just don't know. Arguably, that's inconsistent with the whole thrust of the Act, in which case you couldn't apply that principle, but it's difficult to know. Secondly, very briefly, because it's a slightly different topic, but it's very important. most of us will be familiar with Section 3 of the Human Rights Act, which required courts to interpret legislation so far as it's possible to do so in a way which is compatible with convention rights. That was an incredibly important key part of the Human Rights Act, perhaps in many ways key to its success, because what it provided for was that when you have an apparent conflict between the convention on the one hand and legislation on the other, you as it were, you don't break, but you bend the domestic legislation in a way that makes it fit with the European Convention. It avoids the need for declarations of incompatibility. It avoids potentially the UK being in breach of its international obligations. There were well understood limits to it, set out in case law, which I won't go into now, but it was an important part. Now that's just gone. There's no equivalent to, that's one of the things that's not replicated in the new act, or the new bill, whatever we're supposed to call it. And that seems certainly likely to lead to more declarations of incompatibility. It opens up more likelihood of the UK being found in due course to be in breach of the convention in the Strasbourg court. It's also, and this is the last point I'll make on this, as I say, it's slightly off the top of the main topic thrust of the talk. It's also, I think, a recipe for legal chaos, because it leaves wide open a question which the bill doesn't fully resolve, which is what happens to legislation which has been interpreted by the courts under the Human Rights Act previously, so Section 1 of the such and such Act has been interpreted, would have been interpreted to be incompatible with the European Convention. Under Section 3, a court declared, perhaps a court of appeal decided it meant something else in order to make it compatible. The mandate for that, Section 3 of the Human Rights Act, is gone. Does the court now revisit that interpretation? I don't think we know that for sure. If it does, then that promotes a vast amount of legal uncertainty. And there is at least a hint that that's what Parliament intended, or that's what the draftsman's intending in clause 40, which gives the Secretary of State a rather wide-ranging power to amend legislation which has been read down in that way, so as to make it compatible and so as to avoid that problem. But that requires a kind of deliberate act in each case by the Secretary of State or by the government, and it's not going to cover every case. So there's a great recipe there for legal uncertainty and legal chaos. All right, coming then on to the interpretation of convention rights themselves. I think it's important, it goes back to this point I made earlier, that it's critical. You just have to understand all of this by reference to what position was under the Human Rights Act. So Section 2 of the Human Rights Act, as it now is, and as it's always been, largely left the interpretation of convention rights to the courts. Effectively, the courts, it's an international instrument, the courts should interpret it in accordance with international law. But it did say one thing, which was that, and again, the courts may well have reached this position anyway, it said that they must take account of various things, and in particular the judgments of the European Court. It didn't say, perhaps you would think it would be unnecessary, it didn't say that you had to have regard to the text of the convention or the articles of the convention. So i.e. if you're interpreting Article 8 of the convention, you better read Article 8. But of course that may be said to be implicit. I certainly would not have enjoyed making submission to a court under the Human Rights, in the Human Rights Act days, which we're still for now in, that the court should ignore the text of Article 8 when interpreting Article 8. So it may well be thought to be implicit. There are lots and lots of cases on how the courts approached interpretation of the Human Rights Act, but one of the most famous and usefully encapsulates two important points is the Uller judgment, Lord Bingham, one of a relatively early case which has largely survived in the decades since. So he said, in determining the present question, a question of interpretation, the House is required by Section 2.1 of the Human Rights Act to take account of any relevant Strasbourg case law. He said, while such law is not strictly binding, it has been held that courts should, in the absence of some special circumstances, follow any clear and constant jurisprudence of the Strasbourg court. And he made the point, this reflects the fact that the convention is an international instrument, the correct interpretation of which can be authoritatively expanded only by the Strasbourg court. So he made the obvious and simple point there, that what we're trying to do when we interpret the convention under the Human Rights Act is interpret what it means as an international instrument, and therefore the best guide to that is Strasbourg case law, because that's the court which is responsible for the convention. That's the first point. My 2 points at the bottom of the slide. Aim is to follow the interpretation of the European Convention as an international treaty. The second point he made, which has been more controversial, but which I think has survived, is at the bottom of the quote: the duty of national courts is to keep pace with the Strasbourg jurisprudence as it evolves over time, no more, but certainly no less. In other words, it's come to be known as the Uller principle. I've set it out at the bottom. You don't generally get more expansive, more generous in your protection, more radical in your interpretation of the convention than Strasbourg has so far been. You follow Strasbourg, but you don't go further and find rights that Strasbourg itself has not recognised in the text of the convention. So that was the pre-existing position under the Human Rights Act. Where do we end up under the new bill? Well, there are actually quite a lot of provisions here which deal with interpretation. The most important one, and the one I'm going to focus on, because some of the others are, sorry, it's not the most important, but the most general one is Clause 3, interpretation of convention rights. And there are going to be other talks about some of these others, but you need to be aware of them to get the overview picture, and other people will talk about the detail of them. So Clause 4 deals in particular with freedom of speech, Clause 5 with positive obligations. We're going to have separate talks on those, and then Clause 6. And they're all explicitly about interpretation. And some of the others are also arguably about interpretation. So Clause 6, public protection, Clause 7, decisions properly made by Parliament. I think Fiona's going to say something about that in a minute. Clause 8 is all about deportation. So being aware of those in general, I'm just going to focus on Clause 3 for the rest of my session. Here we go. So this is the slide I wanted. So Clause 3 then, as I say, is the most general interpretive clause to be contrasted with the later clause. And I'll take it in two sections, one on this slide and one on the next. So the first one, Clause 3.1, the Supreme Court is the ultimate judicial authority on questions arising under domestic law in connection with the convention rights. That again is basically declaratory. In fact, it's repeating what we've already looked at in Clause 1, and it's not having any legal consequences because it's already true even before this act was passed. So again, it's a bit of an odd provision. Clause 3.2, perhaps more important, a court determining a question which has arisen in connection with a convention right, A, must have particular regard to the text of the convention right, and interpreting text may have regard to the preparatory work of the convention. May have regard to the development of the common law of any right similar, and then sections 4 to 8 of those more specific provisions, which I've already talked about. So what's all of that doing? Well, first of all, it's telling you must have regard to the text of the convention right, but I've already made the point that I don't think anyone would have thought that interpreting the convention under the Human Rights Act, you shouldn't have regard to the text. Indeed, it's absolutely critical. You certainly may do. I would have thought any judge would say that it was mandatory to have regard to the text of the convention. Does the word particular add anything? Well, it's a bit of an injunction. I think the idea of it is back to that sort of idea of an originalist as opposed to a living instrument type approach to interpretation. So in other words, we should interpret the convention as it was intended to be by those who drafted it back in the 1940s and 50s, not as it's been interpreted 50 or 70 or whatever we are now years on. Trouble is, it doesn't really say that. You can't, that's probably what lies behind it, but can you get that from the word particular in Clause 3.2a? I think a judge might be very slow to think that he should reject the whole living instrument doctrine and his duty to interpret it in accordance with international law, just because the Parliament has used the word particular. And then we're back to that debate which I started with. Well, how much are the courts willing to infer from the kind of mood music a different approach to interpretation than the one they previously have? We don't know the answer to that. I think it's really unclear, but it shows the difficulties of interpreting under this Act. May have regard to the development under the common law. Well, the courts have really emphasised this anyway under the Human Rights Act, that they should look to the common law first, and that will be relevant to the interpretation of conventional rights. The most notable case on that is Unison. So again, is that doing very much? Maybe, maybe not. Clauses 3.3 and 3.4. This is potentially more important, but again, it throws up some problems. A court determining a question which has arisen in connection with a convention right, A, may not adopt an interpretation of the right that expands the protection conferred by the right, unless the court has no reasonable doubt the European Court of Rights would adopt that interpretation if the case were before it. So just pausing there, that's again saying courts shouldn't be expansionist. They shouldn't interpret the convention more generously, giving more protection, more rights to people than Strasbourg has already done. Again, is that new? Well, no, it's very close to the Uller principle. Maybe it's a slightly stronger version of it. Maybe it becomes important that it's adopted into the into the statutory language. And after all, the Euler principle, although it's currently, I think, got House of Lords and therefore Supreme Court authority behind it, has occasionally been questioned. It wouldn't be open to question now, it's in the Act. But is that doing very much? Well, arguably not. And then B, subject to paragraph A, so subject to paragraph A, subject to not being more expansionist, may adopt an interpretation of the right that diverges from Strasbourg jurisprudence. In other words, you're not bound by Strasbourg jurisprudence. Well, again, is that doing very much? Think back to the quote from Euler that I showed you relatively a few slides ago. Lord Bingham's made explicit, and the courts have always recognised they are entitled to depart from Strasbourg jurisprudence. That's implicit, if not explicit, in Section 2 of the Human Rights Act. Is that doing anything more? Query whether it really is. But again, it throws up that issue, because Parliament obviously thinks it's doing, or sorry, Parliament, we don't know yet, hasn't passed it, but certainly the draftman thinks, or courts will want to think that the draftman thinks he's doing something for real with these provisions. Will the courts then read those provisions as going further than they explicitly do, not just permitting a departure from Strasbourg case law, but encouraging it, mandating it, not mandating it, presumably you can't be required to depart from Strasbourg case law, and that would be inconsistent with the text, but how far the courts will go, just a bit unclear. Clause 3.4 makes an odd exception for free speech, which you can only really understand when you look at clause 4, which is going to be the subject of a different talk. But the court, having adopted this kind of minimalist approach to the convention, it then said, well, that doesn't apply to free speech, because the perception in some quarters that free speech is unduly restricted by other rights. What about the status of Strasbourg case law then? Well, remember that Section 2 of the Human Rights Act tells you you must have regard to Strasbourg case law, but you're not bound by it. And we saw that Lord Bingham had said, well, you should generally follow it all the same, but you're not bound by it. The bill does not expressly say that the courts are required to have regard to the Strasbourg case law, but it doesn't prohibit it. And one would have thought that courts would therefore have no difficulty at all in thinking that interpreting an international treaty which has been incorporated via the Act, they should have regard to the case law of the European Court, the court that's responsible for, primarily responsible in international law for interpreting that treaty. So it would be very, very surprising if the courts were to infer that they shouldn't have regard, or they should do anything other than always have regard to the Strasbourg case law, though they're no longer expressly told they must do so. But actually, you can go a bit further than that analytically, because if you just think back to clause 3.3 or section 3.3, as it will be, as I showed you a moment ago, that tells you in terms that you have to have regard to Strasbourg case law for certain circumstances, because 3a, you're not allowed to adopt an interpretation which is more expensive than Strasbourg. Well, you can only follow that approach in that regard. You have regard to that case law, and indeed you follow it in the sense of not going beyond it. But equally, surely implicit in 3ab, subject to paragraph A, may adopt an interpretation of the right that diverges from Strasbourg jurisprudence. So there's an explicit permission to diverge from Strasbourg, but you can only do that, and you can only know that you're doing that if you have regard to the Strasbourg jurisprudence. So although we don't have that express requirement to have regard to Strasbourg case law, you're still required to do so. All very odd, you might think. And it seems to me, and this is where I'll finish my talk, but it brings me again back to that fundamental question of what the courts are going to make of all this, because it's possible to read almost all of these provisions that I've been dealing with. This is not true, I should say, some of the more explicit provisions on freedom of speech and deportation and the like, but certainly the general provisions that I've been dealing with, which will cover most topics, as really not saying very much at all. But it's obvious that the government wants it to be doing something, or wants people to think it's doing something. And so the question of interpretation, which is in a sense a question of interpretation of the bill, is, are the courts willing to read into this something stronger than that they're permitted to have regard to the case law and follow it and so forth? The only kind of hard edge rule is the statutory Euler rule, the section clause 3.3a, but even that we've already got, so it's not really new. And beyond that, they don't seem to do very much. But will the courts infer that it must be intended to do something, and therefore they should be now looking positively to depart from Strasbourg case law? I don't know the answer to that question. I'm not sure that the draftsman of the bill knows the answer to that question at the moment. but that's a thought I will leave you with. Thanks very much for this.
Hello. So I've called my talk It's My Way or the Highway, or you might even say my gaff, my rules, in a very kind of non-lawyerish way, because my talk is largely about clauses 7 to 10 of the bill, which seek to deal with, in effect, deference to Parliament. So how the court should interpret or should act in order to interpret the legislation before it under the new bill, and how to give deference to what Parliament has decided. Now, a bit like Tim, I'm not here to make any political points, but just like Tim, some of the points that I am going to make are really about whether or not what is in the bill is necessary, or whether or not it simply replicates what is how the courts have already been interpreting the Human Rights Act as it existed. So, right, so I'm going to be focusing, as I've said, on clause 7 and 8, and then clause 10, clause 6, 7 and 8, and then clause 10. Clause 6, 7 and 8 deal with how you are going to be interpreting acts of legislation, and how you interpret whether or not there is incompatibility with the Human Rights Act. One of them is general, two of them are specific, and then to deal with declarations of incompatibility. Now, I looked up how many declarations of incompatibility there have been this morning, and there have only been 42 in the 22 years since the Act was enforced. So that's a sort of a couple a year, really. So largely, declarations of incompatibility have been an underused remedy sought, largely because luckily, there isn't very much legislation in this country which has been considered to be in breach of the Human Rights Act. So it's a relatively small number of cases that you're dealing with, most of which are, or a large number of which seem to deal with registration rights and slightly more arcane areas than those areas in which you might have thought the bill was more focused on. So I set out the text of clause 7 here in ridiculously small font, but there are several limbs to clause 7, which is the general clause, and this is headed decisions that are properly made by Parliament. What I think it is seeking to do is, in effect, trying to subvent or subvert or ask the courts to basically not mess with or not interpret legislation as being incompatible with convention rights if it has been passed by Parliament. I mean, it begs the question, as somebody's just sent me a text message to say, what is a decision which is improperly made by Parliament? But of course, we have to look at the heading, decisions that are properly made. And just taking you through the legislation, what it says is where the court is determining an incompatibility question in relation to the provision of an act, and if you look down to the bottom, an incompatibility question is any argument that the provision of an act is incompatible with a convention right, or, and this is probably more important because this is more likely to be how it happens in practice, a public authority has either acted or is proposing to act in accordance with a provision, or does so in a way which is incompatible with a convention right. So in other words, any public body, when it's exercising its statutory functions, as most of the time it cannot do so without exercising its statutory functions, if it's argued that that is incompatible with a convention right, then this clause 7 of the bill arguably comes into account. And it's therefore necessary to determine whether or not, so there's that. So arguably this encompasses the vast majority of decisions which may well be challenged under the Human Rights Act. Certainly all of those which involve a public authority and an individual. There might be slight differences in terms of horizontal rights between two private bodies, but I'm not going to get into that now. So But the second part, little b, is in order to determine that question, the court has to decide whether the effect of the provision, whether considered alone or with any other relevant provision or matter. So that's going to be possibly whether the text of the particular section of the Act itself, or in line with the way that it's interpreted via statutory guidance, for example, or with other bits of the Act, the effect of the provision on the way in which the convention rights are secured strikes an appropriate balance between different policy aims, between different convention rights, or as between the convention rights of different persons, or as between any combination of matters mentioned in some paragraphs 1 to 3. So we've got here a real mixture of different issues. So it not just you're attacking an act on the basis that it's a breach of a convention right. And it's interesting they've used the word act rather than act and or subordinate legislation. It's not clear to me. I think it probably would include subordinate legislation, but that's not expressly clear because at other parts of the Act they use the term act and or subordinate legislation. And it is necessary for the court to look at whether or not the particular Act of Parliament or the particular piece of legislation is striking a balance between different policy aims and as between different convention rights or as between the convention rights of different persons. Now, in some areas, I'm just going to use immigration as an obvious example, that should be obvious. So I'll come on to discuss the deportation provisions in a minute, but it should be, it is usually the case that you are striking the balance between the population as a whole and those who are subject to immigration control in the way that legislation is determined in respect of immigration, who can come in, how they come in, whether or not they are made to leave or whether or not they leave of their own volition. But there would be lots of other areas where it might not be immediately obvious that there has been a balance between different policy aims. I mean, I would think of lots of things. So, I mean, the first question that I pose in my mind, if I'm playing devil's advocate, is, does that mean that you have to look through the debates in Parliament or to decide whether or not this is a bill which is striking an appropriate balance between different policy aims? What's meant by policy aims? Policy aims are not described in the legislation. Are you just talking about what sort of policy? Because largely legislation always is striking a balance between policy aims, usually between the fiscal, usually between the necessity to keep the balance, the books in effect, fiscal rectitude, and the needs of the populace to be provided with services. I mean, those are two different policy aims. Does it mean that? I don't think it's meant to mean that. But again, just like Tim, some of the drafting of this doesn't seem to be very clear. And as between different convention rights. Now, we all know really what's being got at here, which are the qualified rights, Article 8, right to privacy, Article 9, freedom of religion, Article 10, freedom of expression, Article 11, freedom of assembly, and then Article 14, which is the discrimination right, and Article 1 of the first protocol and Article 2 of the first protocol, because they are both the most obvious kind of what I would call qualified rights. So I think that that's what it's looking at. As between the convention rights of different persons, again, in some areas, immigration, that's obvious. In other areas, it might not be so obvious as to whose rights might be being infringed or different convention rights of different people. So I think I've already dealt with when it will apply. So I think this is going to apply in a widespread way. So I am assuming for these purposes that the bill becomes an act, that the act is roughly similar to what's set out in the bill, and in which case I think certainly when it comes to challenging public authority decisions based upon provisions set out in legislation, there is a likelihood that you are going to have to look at clause 7. So, and I've already identified that there are very many ways in which where it is necessary to decide whether the effect of the provision. So I suppose you could say it only applies where it is necessary, and necessary having been interpreted by courts on many occasions as really needed. So if there are circumstances whereby there has been a dispute between different policy aims, but it's not necessary to look at those different policy aims to decide whether or not the convention rights are secured appropriately, then you don't need to look at clause 7. Again, I'm not sure that the drafting necessarily assists with the clarity that will be necessary when it's coming to interpret how we actually look at this in practice. So what does the court or tribunal have to do? Well, in effect, what the court or tribunal should do, if it is in the position that I've just described, is regard that Parliament as having decided in passing the Act that it strikes an appropriate balance between the matters set out above, i.e. that it has considered and struck the balance between different policy aims, convention rights, or the convention rights of different persons. Secondly, because there are two things that the court has to do, give the greatest possible weight to the principle that in a parliamentary democracy, decisions about how such a balance should be struck are properly made by Parliament. Now, I'm not so sure that those aren't saying the same things in two different ways, because in effect, in a parliamentary democracy, we all recognise Parliament is sovereign. Decisions about how the balances are to be struck in various acts of Parliament are something which is the subject of political debate and discussion, and we recognise that already in the way that we interpret legislation and the way that we've interpreted the Human Rights Act and legislation passed under it. However, it is the case as well that because Parliament is sovereign, we usually already determine that it has considered and struck the balance between different policy aims and convention rights or the convention rights of any persons, largely because under section 19, it usually says this act accords with the European Convention on Human Rights. And therefore that process has already been gone through, either at the pre-legislative stage when deciding what to introduce, during the scrutiny of the bill or the act, or in the way that the act is to be interpreted through the supporting nature of statutory guidance and policy advice. So I'm not entirely sure that they aren't really saying the same things, just in two slightly different ways. And the point that I think Tim's made already in his talk is exactly the same point that I've made, which is the court already does it. It is, of course, our fundamental constitutional principle that Parliament is sovereign. If what it's trying to do is to indicate that Parliament is sovereign and put that into a legislative form, I query whether or not that's necessary, and I also query whether or not that is in fact what has happened. Secondly, it is well known, and we can see the most recent decision which articulates this very clearly is the SC case last year in the Supreme Court about welfare benefits and about what was called the two-child policy. And the Supreme Court was absolutely clear there that the court does not take over the function of the decision maker and doesn't substitute its own views on matters of policy judgment and discretion. And particularly when we are dealing with economic and social policy, there is a wide margin of discretion used. So simply because a group of people are not happy with it, so for example, those who had more than 2 children which were born after the Act came into force, and therefore they would get less money by way of state security benefits, simply because they were unhappy with it. Parliament had debated all those issues, and the SC case, I think, is a prime example, or probably the most recent example, of the way that the courts have regularly interpreted, in particular, economic and social policy. And it seems to me that what might be being got at by clause 7 is a kind of more general introduction of the margin of discretion arguments, or maybe just a re-emphasis of those arguments which are already necessary. However, my concern with it is, does it in effect? So I've got a number of concerns about the usefulness and efficacy of the clause. I suppose what I would say is, firstly, does Lim A seek to dictate the outcome of a proportionality test? So is what it's trying to do is telling the courts how they are to look at proportionality. And as we know, proportionality is, in qualified rights cases, what one is looking at. And therefore, if they are saying that if an Act of Parliament has been passed, in effect, you don't look at proportionality, or you don't have to look at doing so, then that would seem to me to be in breach of the convention, because you're not looking at the text as drafted, which expressly requires that something is necessary in a democratic society, as all of us know, having looked at one or other of those articles which set that out. And if it doesn't, then why are we introducing this clause? Again, I don't think, if what it's trying to say is you have to be careful and you have to think about the margin of discretion, margin of appreciation, call it whatever you will, when you're looking at attacking policy making which has been passed by an Act of Parliament, that has already happened. The other concern I have is what the impact of it will be. Will it have an unnecessarily chilling effect? Because the idea, if one goes back to clause 7, it doesn't say you can't undertake the proportionality test. It just says when you're undertaking the proportionality test, you should give the greatest possible weight to the fact that Parliament has passed it as an act. So either it's not necessary as a clause because it is superfluous, or it's seeking to subvert judicial discretion when it comes to assessing where the balance should be struck, something which, as far as I'm concerned, will inevitably lead to the possibility that Strasbourg will say that the domestic courts has acted in breach of the convention by not upholding a significant part of the text and convention rights. So I suppose my major concern is what's it for? What purpose does it really serve? My view is it doesn't really enshrine the principles as I would like them to be articulated if what you're talking about is the margin of discretion. And I think it has the consequence of potentially having an unnecessarily chilling effect on the judiciary. And in particularly the areas in which I was just thinking about this morning, in which I can see an obvious impact, will be social security cases, claims related to state benefits and grants, where there's often competing rights at play, housing issues, immigration issues, privacy claims. Any claim brought under Article 14, I suspect, may well be caught by this. And Article 1 of the first protocol I was thinking about in terms of compulsory purchase planning issues, where there are a distinction between the rights of the local authority to build or the rights of the government to build a railway versus the rights of the person who's having their house demolished in order so that that railway takes effect. There are then some more specific attempts, I would suggest, to strike the balance in a particular direction. And that is firstly in respect of clause 6, which is only to do with those who are serving a custodial sentence at the time when the breach of convention rights occurs. So it is a niche series of individuals to whom clause 6 applies. And what it then says is, in any case which involves any convention right other than 2, 3, 4 and 7, which is the right to life, the right against inhuman and degrading treatment, the right not to be subject to slavery or forced servitude, and the fact that there should be no punishment and law. If any prisoner, I'm going to call them a prisoner, who is in prison or who was in prison at the time when the breach was alleged, alleges that there's been a breach of their convention rights, then the court must give the greatest possible weight to the importance of reducing the risk to the public. And they also indicate clause 6.3 specifically says that this is particularly the case, firstly in respect of whether or not to release them from custody. So it seems to me that that is, and the explanatory notes say so, that this is in effect a direct attempt to deal with problems as they have been perceived to be in respect of the parole board releasing people when they don't think that it's the case, or which part of prison somebody should be placed in. And it specifically says that. So this is to deal with a particular set of issues which have caused a political furore. And this is set out clearly at paragraph 33 of the explanatory notes, which I will leave you to read at your leisure, which is to strengthen the government's hand in contesting human rights claims from prisoners, and to strengthen the government's ability to defend human rights claims regarding the deportation of foreign national offenders. Now, whether or not, in fact, it actually does that is another matter, but that is expressly the government's intention. The issue of deportation is going to be dealt with in more detail at the third seminar, but just to briefly indicate, under clause 8, what it does is really re-reflect and strengthen the legislation which has been enforced now in various forms over the past 10 to 15 years, making it increasingly difficult for those who are subject to such deportations to challenge their claims using the Human Rights Act. What it basically says is it is only if a child or other member of somebody's family, and that's given quite a short definition, causes manifest harm that is exceptional and overwhelming, that's so extreme that it is exceptional and overwhelming. Again, exceptional and overwhelming are not defined. Having spent quite a long time, about 5 or 6 years ago, trying to work out in front of a court what the test of something being overwhelming meant, I can tell you that is not an easy task. In effect, you shouldn't really take account of any of these issues absent an exceptional and overwhelming issue which cannot be mitigated in any way. The next issue is declarations of incompatibility. Now, as I've already said, there were only 42 of them. Tim thinks there's going to be more. I definitely think there are going to be more. The text of the new bill is identical to that of the Human Rights Act, save in one respect, which is that it permits subordinate legislation to be the subject of declarations of incompatibility. Now, I think that's had to happen because they've got rid of what was Section 3 of the Human Rights Act. So what is now going to have to happen is, if you are arguing, as in very many areas, as we know, most day-to-day legislation in terms of how you actually make something run takes place in subordinate legislation, regulations, rather than an act in and of itself. There was a general rule, which was subordinate legislation should always be read in a way which is compatible with convention rights, unless by reason of looking at the original statute, which brings the regulations into force, you couldn't do so. What it in effect meant that you could kind of segue off and or get rid of bits of delegated legislation which resulted in a breach of the convention. You could just ignore them and just apply the rest of it. That is not going to be the case. What you're going to have to do is either say that the regulation should be struck down, because you're no longer arguably going to be able to rely upon the Section 3 should be read in any way, even if it's a strange way, or you're going to have to ask for a declaration of incompatibility. But again, what I'm not clear about is why you would need a declaration of incompatibility when you've got the power to quash. You've always had the power to quash. What the court can do under this new clause 10 is, instead of quashing, it can simply order a declaration of incompatibility. So if, for example, you have an issue which is of great political controversy, or where there is a divided view, and you are looking at whether or not you are going to quash a piece of delegated legislation, I think a more nervous judge, shall we say, or a judge who is cautious, may well not quash the regulation, but simply issue a declaration of incompatibility. Again, we are all internally questioning, is it needed? I mean, it seems to me I'm not sure why it's needed instead of the quashing. But anyway, this is all for another day. I think what it's trying to do is trying to encourage not quashing regulations and making declarations of incompatibility. Whether or not, in fact, it does that is another matter. So now that I have given you a whole series of questions, and unfortunately not as many answers as we would all like, I pass over to Charles, who's going to talk all about the new permission stage. Thank you.
Thank you, Fiona. I'm just going to be talking today about the permission stage, which is introduced by this bill to certain human rights claims. I'm going to start, though, by looking at how you bring a human rights claim at the moment in terms of who actually can bring it, because we need to understand that to understand what the implications of this permission stage might be. And then I'm going to look at what's actually changing and considering some of the practical implications of that. Unlike the areas that Fiona and Tim have outlined, we do know that this permission stage change will definitely have implications for practitioners in terms of procedure. I think there is a question over how much it's going to affect the substance of someone's claim in terms of what outcomes they're actually going to get at the end of the day. So just a recap of the current status of the law, public authorities are under a duty to act compatibly with convention rights. We know that, but we also know that you can only allege that a public authority has contravened convention rights if you are actually a victim or would be a victim of that unlawful action. That, however, does not apply in relation to a challenge to the compatibility of legislation, which is what Fiona and Tim have been discussing in some respects. So if you raise an argument in court that legislation needs to be interpreted in a certain way, you currently do not need to demonstrate that you are in fact a victim of a convention right violation. So who is a victim? Well, that's essentially defined by reference to the European Convention on Human Rights, Article 34. There's no additional meaning that's added on top of that. You literally look at what Strasbourg says on this and you take it from that. And what Strasbourg has said is that those who are directly or indirectly affected by the act or omission in question are a victim under the convention. And that applies in particular in relation to indirect victims, to those for whom a violation would cause harm or who would have a valid personal interest in seeing it brought to an end. Now, indirect situations are primarily related to close family members of someone who has died. In certain situations, they can bring a claim. So they were not themselves the victim of a violation in terms of that the breach of the right to life didn't cause the actual applicant's death. But what the applicant says is that it breached the right to life of my close family member. And as a result, I've been indirectly affected by the violation and I can therefore bring this claim. The case law on victim status, it's a little bit messy and there's not a sort of clear taxonomy of principles that you can apply. And that's very much the same as in relation to standing and judicial review proceedings in the UK. This is essentially a case-by-case basis test. So what I've put on this slide are really just some of the principles that are applied in certain cases. So for example, in the case of whether or not a secret measure has violated someone's human rights such that they are a victim, well, it's enough to show in those cases you're a potential victim that it could be applied to you. And similarly, where the existence of a law might affect your behaviour, even though you're not actually, the law hasn't been applied to you. So the best example of this is the criminalisation of homosexual activity in the Dudgeon and UK case. There, in application, the applicant hadn't necessarily been prosecuted under the prohibition on homosexual activity, but it had nevertheless had an effect on them, which meant that they were still a victim because they weren't able to live their life in the way that they wanted. And similarly, in removal cases, you would argue that while you haven't actually been a victim of inhuman or degrading treatment, you're saying, if I was removed to this country, I would be a victim of inhuman or degrading treatment. And the courts in those cases all accept that you are a victim under Article 34. And there's some interesting cases about when this applies in relation to a benefit that you are not eligible for. How do you actually demonstrate you've been affected by the provision? And the courts in the UK have said, well, you have to do something which shows that you would have made a claim if you could have done. And ultimately, you have to demonstrate that you run the risk of being directly affected by the measure. So that's just a recap on victim status. And we'll see now why that's important. So this is now clause 15 of the Bill of Rights bill. And this introduces the permission required to bring proceedings requirement under clause 15.1. No proceedings under section 13.2a of the Bill of Rights bill may be brought unless the person has obtained permission from the court. So what proceedings does this relate to? Well, what is clause 13.2a of the Bill of Rights bill? That is essentially the duplication of section 6 of the Human Rights Act that we looked at earlier, which is the duty to act compatibly with convention rights. So that's what we're talking about. It's those situations when you're alleging that public authority has acted unlawfully because they have contravened convention rights. It's not about situations where you'll be relying on a convention right in another proceeding. So if you have been prosecuted and charged with a criminal offence and you want to raise the compatibility of the legislation under which you have been charged with human rights, this permission stage doesn't come into it. You don't need to worry about it in those cases. And that would also apply, I think, also in relation to, for example, a human rights defence to a claim for possession, or in relation to any private law cause of action. And also there are some explicit carve-outs in the bill, so it doesn't apply to judicial review claims in Scotland or Northern Ireland. YASA is going to be dealing with the devolution issues within this bill in the next session, which is on Wednesday. The permission stage also doesn't apply to proceedings before the Investigatory Powers Tribunal, and also doesn't apply to proceedings relating to a deportation order in respect of a foreign criminal. I mean, I suppose in that case, it probably wouldn't matter in most cases because I think it would be relatively easy to obtain permission in those cases. So how do you get permission? What does the court have to do? Well, the court has to consider that you are a victim of the act, and we've looked at that already. And the court also has to consider that you have suffered or would have suffered a significant disadvantage in relation to the action that you are alleging is in breach of human rights. So it's 2 stages: victim test and significant disadvantage test. Now, the victim test is essentially the same as it is under the Human Rights Act. So it again is incorporated by reference to Article 34 of the ECHR. But important thing is that this is now going to be considered at a much earlier stage in the process. So at the moment, if a defendant to a human rights claim wants to say that the claimant isn't a victim and so this case should not proceed, they would have to make an application to strike out the claim or use some other procedural device. Now it's built into the claim, so it has to be considered at an earlier stage. The burden's no longer on defendants to do this, and it's likely to be, now it needs to be dealt with up front when you're bringing a claim and pleading it. So turning then to the next limb of the test, the second limb, and that's the requirement to show significant disadvantage. And this is the innovation that is brought by the bill. This is the crux of it. Now, significant disadvantage is essentially defined by reference to Article 35 of the European Convention. So for once, we actually are not needing to interpret this kind of abstract concept by itself. It's not a new concept. It's actually a concept for which there is case law we can look at. The text of Article 35 doesn't really take this further. You really have to look at the case law and the principles. Just by way of background, it's interesting to note the history of Article 35. It's actually only been in force since the 1st of June. The specific significant disadvantage provision has only been a requirement for a claim to be admissible in the European Court of Human Rights since the 1st of June 2010. But the idea behind it was first agreed in 13th of May 2004, and there was a lot of negotiation leading up to it in the years before that. And really the idea behind it was to address what was at that stage quite a significant backlog in the court's caseload. And so the idea was to try and reduce the number of cases the European Court, International Court had to deal with, coming from all of the over 40 member states of the European Convention. And so just while acknowledging what we have said in that we are not here to discuss the merits or problems with introducing these parts of the bill, there is no clear analogy between Article 35, which was designed to address a very obvious and evidenced backlog in the court's caseload, with the present situation, where there has been no evidence of a backlog of human rights claims in UK courts being presented by the government. So it's sort of using a different technique for a different purpose. So what is significant disadvantage? The European Court has said that it hinges on the idea that some violations of rights are more serious than others, and that if a violation of a human right is to be considered by an international court, the European Court of Human Rights in Strasbourg, there should be a minimum level of severity to it in order to warrant the attention of a supranational body. And the courts acknowledge this is very much a case-by-case assessment. It's relative. It depends on all the circumstances of the cases. And while one looks at the subjective perception of the applicant, so do they think they have suffered a significant disadvantage, that is not enough, because what they think has to be based in some kind of reality. There has to be some objective ground behind why they think they've been significantly disadvantaged. And in the context of situations where the disadvantage might primarily be on the basis of some kind of financial disadvantage, the courts have said, well, it doesn't have to be always a financial disadvantage. So, for example, in an Article 1 of Protocol 1 case, you don't necessarily have to show significant pecuniary disadvantage if there is an important question of principle within the violation. Now, what's very interesting is that the Strasbourg Court has adopted a very different approach to how it determines whether or not an applicant has suffered significant disadvantage, depending on which article is in play. So what you can see on this slide is a summary of those principles. And what you see is that particularly Articles 2 and 3 and 5, the significant disadvantage principle doesn't really actually apply as a bar at all to bringing a claim. And I think that reflects really that all threats to the right to life, all threats or actual violations of the prohibition on torture and inhuman or degrading treatment or punishment, and all threats to your liberty and security are going to have led to significant disadvantage. Whereas by contrast, in relation to Articles 9, 10, and 11, so freedom of thought, conscience and religion, freedom of expression, freedom of assembly and association, all those claims are also considered to be important by the European Court. So you can see, the court has to take due account of the importance of these rights, but it's unclear really how far that takes you in terms of how much scrutiny do you apply at this stage. You can see the court recognizes that in those cases there is a role to play on the significant disadvantage provision. And then in other cases, the court has said that essentially the focus is very much on severity, and you determine severity in particular by reference to what is at stake, what could be the outcome of this case. And it's also quite interesting to note that the court has in these situations taken into account an applicant's conduct. So where the applicant didn't really seem that bothered and hadn't really participated actively in the court proceedings, that was used against them to say, well, you can't really be significantly disadvantaged if you don't actually care that much about your case. So that's something to bear in mind in terms of when practitioners are advising claimants in terms of how they should demonstrate significant disadvantage. So there is an exception to the requirement to demonstrate significant disadvantage, and that is where the court determines it's appropriate to do so for reasons of wholly exceptional public interest. So you wouldn't need to show in those situations significant disadvantage. But it's not very clear what wholly exceptional public interest actually means. And what's notable is that while the significant disadvantage requirement is defined exclusively by reference to the wording of the convention in Article 5, this wholly exceptional public interest test does not derive at all from the convention, which has a wholly different exception approach, which is simply that you don't need to demonstrate significant disadvantage where respect for human rights requires an examination of the application on the merits. It's a much more straightforward test. So I think the courts are probably unlikely to follow the Strasbourg jurisprudence on that exception, and they'll have to consider that, well, Parliament must have chosen for a reason why they didn't adopt the Strasbourg jurisprudence. So it must be something more, it must be something wholly exceptional. it's unclear what could be exceptional but not wholly, unwholly exceptional. I'm not sure what that would mean. And unfortunately, this is probably going to lead to a significant amount of litigation, which is probably the case in relation to quite a lot of this bill. So I think one category where that probably would be the case and where there might be some similarity with the Strasbourg jurisprudence is in relation to cases where it's important to determine the case to resolve an important point of law. So just going briefly through the rest of the architecture of this permission stage, if you're refused permission, you can appeal it. And it's a bit like a refusal of permission to bring claim for judicial review, which allows you one appeal, but no more appeals. So if the next court refuses you permission, then that's it. You cannot go further. And the actual framework of how this is all going to work is going to be made in rules, which will be laid down, I think, in conjunction with the court and the government. So it's going to be subject to a procedure, and the actual operation of how this is all going to work is unclear at this stage. So really, what was the point of the government's idea behind this? And you get a sense of this from the explanatory notes and from the proposals that preceded the Bill of Rights bill. So there was a consultation document and a response to that consultation document published with the bill. And the ultimate ambition is to ensure trivial cases do not undermine public confidence in human rights more broadly. One thing to note is that these proposals did not enjoy public support at all. 90% of respondents to the consultation did not support introducing a significant disadvantage requirement, but the government thought it was important to do so and has done so. But they have, in doing that, decided to tie it more closely to the Strasbourg case law. So what's this really going to mean in practice? Well, obviously, there's now going to be a big difference to how one has to approach a case. There's a whole new stage in the proceedings. Proceedings will therefore probably take slightly longer and may cost more because there's a new requirement to overcome. But there's also, interestingly, contrary to what the approach is in relation to interpretation of convention rights, there's now renewed importance on Strasbourg authorities in relation to both victim status and significant disadvantage, because the bill ties interpretation of those concepts directly to the case law of the Strasbourg court. And secondly, it's not clear whether or not in substance this is actually going to be a significant barrier to most claimants, and it's not clear if that was ever really what was intended. All of the sort of policy documentation surrounding it is that the idea is only to actually reduce the volume of cases a bit, because most cases will not be frivolous or spurious in the government's language. And I think that's actually supported by the approach Strasbourg court takes, in that actually this principle doesn't even apply to quite a lot of claims of violation of certain rights. I think the biggest impact, however, is likely to be in relation to rights where there is some sort of proportionality analysis. And in particular, I can see Article 6, so the right to fair trial, and Article 1 of Protocol 1 being prime targets for this test. So there might be quite a lot of situations where a court says, well, yes, the fairness of this proceeding was not quite right, but it hasn't actually significantly disadvantaged you. And similarly, in relation to Article 1 of Protocol 1, again, how much have you been financially affected by this? If it isn't significant, then the court might not allow your claim to proceed. I think there's an open question of the extent to which the Strasbourg court's varying approach to the different articles is actually going to carry through to domestic case law. So would it actually be unlawful for a court in this jurisdiction to apply a significant disadvantage test to an Article 3 claim? I think there's arguments both ways on that. I can see how you could find a way to argue that the court could do it. And it seems that the idea is that the burden is not simply to say, if the facts that I've alleged have happened, then I would have suffered a significant disadvantage. It seems that the intention is that you would have to actually prove on evidence initially that you have suffered that significant disadvantage. You can't just show, well, let me go to trial because I'll prove to you that I have suffered significant disadvantage. It seems that you actually have to prove that earlier on. And I'm not sure how that's really going to work in practice. We're going to have to see what the rules say on that. And the impact assessment suggests it's primarily supposed to be a paper-based procedure, which perhaps suggests that what I just said may not actually be the reality, in that actually, if you're in a civil damages claim, the permission stage may actually be not quite significant, because ultimately the court doesn't want to have to go through the process of determining whether or not you suffered significant disadvantage, which will hear a lot of evidence, and then proceed on to the next stage of hearing the whole claim anyway. And then there's a question over in a judicial review where there's a permission stage already, which is essentially whether it's arguable. Well, do you have to show that you arguably suffered significant disadvantage? Or would you have to show at the permission stage in a JL that you have actually suffered significant disadvantage? It's unclear how that's going to fit together. And just to reiterate, there's no requirement to demonstrate victimhood to obtain a declaration of incompatibility. And so all the old case law on that remains. But there is no longer this duty comparable to Section 3 to interpret legislation compatibly with convention rights. So it's unclear how that's going to fit into it. And just to flag that the impact assessment also has identified potential costs and benefits to public authorities. And finally, there's a question, is this compatible with the convention? So could you actually challenge this in the European Court, the whole regime? Is the whole regime compatible with the convention? A matter of international law, government seems to think so. So that concludes my presentation. We're now quite late in the day, but we were going to have time for questions. I'll pass on to David now.
Well, thank you very much to Charles, to Fiona and Tim for fascinating presentations, which I think went on slightly longer than we hoped, but just shows you the number of questions this bill raises. We've had a couple of questions. I'm going to ask Charles to deal with one of them. And if participants would bear with us for a couple of minutes, but I'll ask questions to be very precise, or answers to be precise. Charles, the permission stage and has been described, or the requirement to be a victim has been described as being in the press as being an anti-good law project clause. But can I ask, what's the position of the Equality and Human Rights Commission? Is there any provision in the bill for that? And will the Equality and Human Rights Commission still be able to bring challenges on behalf of the people it represents?
So I think there is no specific provision that limits their ability to bring a claim. And so I need to check what the Equality Act 2006 says on this, because the Equality Act 2006 is what gives jurisdiction to the European Commission to bring claims on behalf of individuals. And there's a case, MS and the Home Secretary in the Supreme Court, in which the Equality and Human Rights Commission took over an actual victim's case in a trafficking case. And so the Equality and Human Rights Commission has always had that ability. It's different in Northern Ireland, and there's a case on that, as we know. I think that the position remains the same essentially between the Bill of Rights and the Human Rights Act, but it's not very clear.
Fiona or Tim, have you got any thoughts on that issue?
I think as far as the Equality and Human Rights Commission is concerned, I think it might be one of those things that it would be worthwhile them asking to make an amendment so that it's made clear that they can apply for victim status. I mean, the other thing is that I suspect that any case in which the Equality and Human Rights Commission says that it is a victim would meet the wholly exceptional public interest test, because they're only going to get involved if they think it is wholly exceptional, I would imagine. So I think in practice, it might not be too much of an issue, but that is an obvious example of where maybe people haven't thought through the way that the Act impacts upon previous pieces of legislation. Yeah.
Tim's nodding. I'll go very quickly on to that.
I don't have anything to add. I think it might require an amendment, because I suspect the Standing and Equality Act relates to the Human Rights Act. So if the Human Rights Act, anyway, that's what we don't know.
The final question which has been raised by somebody in the questions, and I think this is very interesting, is Fiona, you were referring to the requirement of taking into account the policy context when making any declaration of incompatibility. And the question is asked this very interesting point, which is, what happens if the policy context indicates that the interests of a particular group has simply not been taken into account?
Well, I think this is difficult, and I say it, I said it on the slide, but then I didn't replicate it in my talk, which is very often claims are brought by people whom nobody thought about or nobody considered, or that particular policy issue wasn't thought about when the Act came in. Now, there are two ways of looking at it. If you take the more generous interpretation, you would say, well, I think when it comes to issues where convention rights are in play, I think that's a bit more straightforward. But the Act says policy objectives, differing policy objectives. And of course, I think it's not clear. And you could say, well, if it hasn't been debated in Parliament, so this is going to involve everybody going back to parliamentary debate and parliamentary discussions in a way that does happen sometimes, but doesn't happen very often, to look and see whether or not the policy objectives, or and what I think is what's being got at is, if it's been passed as an Act of Parliament, the fact that that policy objective hasn't been taken into account doesn't matter, because Parliament is sovereign and Parliament reigns supreme, and therefore the fact that it's a wholly unintended consequence because nobody thought about it is irrelevant. Well,
that's fascinating.
I just say, I mean, well, I was only going to say, I mean, the way I read the bill is that you've just got to presume they balance it, because the bill, section 7, clause 7 says, where you have to balance any rights for the purpose of the convention, that's what I paraphrased, but that's effectively it, the court must regard Parliament as having decided that it strikes the appropriate balance. So you've got to assume, I mean, I'm not saying it's completely clear, but that's how it seems to work.
Yeah. Okay, that's brilliant. One last very quick question, which I think I know the answer to, but which is there an Article 6 argument against the one appeal only rule to which Charles referred? I think the answer is no. If you get one bite of the cherry, and then even under Alconbury, I think one bite of the cherry will be sufficient. Anybody disagree? No.
On that, one question is, if it's decided on the papers, can you ask for an oral reconsideration, and does that count as an appeal? I don't know. There's no answer to that.
At the moment, assuming that it's a general civil thing, if a decision is made on paper, you almost always have a right to renew it orally without it being considered to be an appeal.
Yeah, as a matter of civil procedure, I think that's probably what happens.
So you do get two bites of the cherry, really. Can I, on behalf of people who are listening, many of whom are still here, thank you enormously for fascinating talks, which certainly I learned a huge amount, and I'm confident that everyone on this webinar did. If anybody who's listening today wants to really get a comprehensive view of the provisions of this bill, please join us for the next two seminars, which are on Wednesday and Friday of next week. I think the talk today has shown how wide-ranging the changes are. People will have to form their own view as to whether or not the rebalance is striking the right balance or not. That's not for us. But it certainly raises some fascinating and really, really difficult questions. And I look forward to the next part of the debate next Wednesday. So thank you very much, everybody. And that's the end of the seminar.
Thank you.